A prenuptial agreement, also known as an antenuptial agreement or a prenup, is an agreement made by two parties entering into a marriage that clearly states the ownership rights of each party enjoys in the other party's property. To be enforceable, a prenup must be in writing. A prenup serves to do many things. For example, it protects a party's assets, it protects one party from assuming debt or too much debt. Uh, it determines the distribution of property, it clarifies all financial rights and responsibilities of each party, and it avoids a messy and costly divorce process. There are, though, a lot of things that prenuptial agreements cannot include. For instance, nothing illegal can be detailed in a prenup. Decisions regarding child support and child custody cannot go in there either. A prenup cannot waive the right of alimony. It cannot encourage or give incentive towards divorce, and it cannot include any personal rules. Everything in a prenup usually has to do with financial status. Although these contracts do fall under the statute of frauds, prenuptial agreements are not automatically deemed enforceable when in writing. A lot of judges and courts in the United States do, however, favor those prenups when they do have significant consideration in them. Different states and different countries have their own laws regarding legality of prenups. However, all 50 United States have recognized prenuptial agreements. There are general rules to help ensure enforceability in your prenup in the United States. For one, obviously it must be in writing. Another is that both parties should have a lawyer present. In some cases, couples like to have a private judge present during signing just for safekeeping. Some attorneys also recommend video recording or some sort of recording of the parties' signatures. The rest of it is usually up to state law. A lot of people believe prenuptial agreements is a fairly new term and has not been around for that long. However, the idea of a premarital contract is one that has been in history for many, many years. Ancient Hebrew marriage contract ketubah, which has many similarities to what it seems like today, has been around for more than 2,000 years old. Also, the dowry was often considered a premarital contract as well in early Europe and Asia. A fun fact, General James E. Oglethorpe, founder of the colony of Georgia, was required by his wife to sign a premarital contract protecting her property. Originally, these contracts served to protect wives to ensure them property in the event of their husband's death, and they still do. However, today they more or less serve to protect sizable wealth from messy, messy divorce. The Uniform Premarital Agreement Act is an act drafted by the ULC, the Uniform Law Commission, that governs prenuptial agreements and gives guidelines to such. 27 of the 50 United States have indeed adopted this act. There are 4, Mississippi, Missouri, South Carolina, and West Virginia, that have introduced it into their state, yet have not officially adopted it. For those states who do not follow the UPAA, usually they have their own set of guidelines for such contracts, and they're usually very similar to the UPAA and general contract law. Prenuptial agreements are also fairly relevant around the world in different countries and continents. For example, Australia recognizes prenups through their Family Law Act of 1975. In continental Europe, many courts do deem them legal and enforceable. However, some do have certain restrictions on enforcement. For example, like the United States, they must be in writing. They must be agreed upon by both parties. However, in continental Europe, neither party can challenge the prenuptial agreement due to circumstances regarding how the marriage broke down or certain party conduct. In India, the idea of a premarital contract has been very rare. However, with the rising divorce rate, the rate of prenuptial agreements have raised there as well. They have many marital laws like the Hindu Marriage Act that do prevent a lot of things that premarital contracts have here in the United States. There is one state in India, Goa, that is the only Indian state with enforceable prenup law because they follow the Portuguese Civil Code of 1867. Surprisingly, prenuptial agreements have historically never been considered valid in the United Kingdom. In South Africa, however, civil marriage is by default a marriage and community of property. Therefore, a couple must sign a prenup with a notary present at the beginning of the marriage. Thailand recognizes enforceable prenuptial agreements as well. There are a lot of couples, however, who do not believe they need a premarital contract. And when that's the case, a state-level family law comes into play. In most U.S. states, spouses are, regardless, entitled to a share of the ownership of the property. They're entitled to some property in the event of the death of the other. Each spouse is entitled to a share in any debt, as well as a share of responsibilities in managing the property. Like I mentioned before, there are many couples who believe they do not need a premarital agreement. There are many positive and negative factors into entering these type of contracts. One positive reason is that you have the ability to protect your inheritance rights of your children, although you can't completely delegate child custody. Another one is that if you're a business owner, such contracts can protect you and your business from being divided up among you and your spouse. Most state law deems this as divisional marital property, and in the absence of a prenup, that would happen. Prenups are also a way for one party to ensure compensation, if that party happened to be the only one working with significant income. Also, prenuptial agreements are a way to protect the financial interests of the elderly, of those who are entering into second or even third marriages, and for those with significant wealth. On the other hand, however, there are reasons for why people do not enter into such contracts. Prenups may require you to give up the right to inherit your spouse's estate upon death. Also, prenuptial agreements in general can ignite a lack of trust very early in the marriage. A lot of people do not want to put the what-if factor into the relationship and therefore ignore or avoid these type of contracts. Depending on a certain agreement, one spouse could come out significantly on top of the other financially, leaving the other unable to sustain their own lifestyle. Another negative factor into entering these types of prenuptials is when a couple signs into such contract, it is at the beginning of their marriage, which most people deem as the honeymoon phase. During this period, both the spouses could easily be swayed to make decisions that they later see aren't as beneficial to them as they first believed.